it took me a while. When we were at one of the first hearings, I got Miss Hines's pleadings. I saw that email and she was indignant that the defendants were in there and they were removing property, and she contacted the undersheriff, and I was aware tangentially of the zoning action. There were several actions going on in the summer of 2022. There was a personal protection order between Mr. O'Donnell and Mr. Verpalat in August and July. That was going on. Then there was the zoning case. And that was in the name of Rosemary Blair and the other owners of the property, not in the names of the tenants. And then that was settled. She owned the property. She accepted the settlement. Officer Kuhlman indicated that the property had been made habitable, and I have the zoning, I have the PPO file, I have the zoning file, and this file. So as we got into the hearing and I started to hear Mr. O'Donnell's position, I was offended. Maybe outraged is too strong of a word. My opinion at that point was the plaintiff used the zoning system to force the defendants out of the house. And I have some serious concerns about violation of the lockout law. I felt that they got used. She self-reported a zoning violation. Allegedly, there had been some damage to the deck, but the photographs showed just minor damage to the deck from apparently a tree that had fallen earlier. And then they got under the house and realized that some of the stuff was supported by bottle jacks and it may have been dangerous. So they condemned the house immediately without notice to Mr. O'Donnell and Miss Bowers. And I believe the plaintiff used that as a pretext to terminate the lease with option to purchase. Miss Bowers and Mr. O'Donnell were the lawful occupants of the property on the day that zoning enforcement action took place. The police came out there like I won't say it. Anyway, they came out there. Miss Bowers was asleep. The house was neat and clean. All the beds were made. They were using it for the purpose they had intended. And they came stomping in there, got her out of bed, kicked her out of the house, told her she couldn't stay there, and they were evicted. And I felt at that time, I haven't made a ruling yet, that it violates the lockout law. Then they changed the locks and did some other stuff. And some earlier attorney sent an extremely threatening letter saying, rah, 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 rah.
Your Honor, those letters, if you're looking for them, are Exhibit 9 of our brief in opposition to the motion relief.
They're in the original pleadings as well, but the lockout law, which is found at 600.2918, any person is rejected and put out of any lands in a forcible and lawful manner and is afterwards being held or kept out by force is entitled to 3 times the amount of his or her actual damages, or $200,000 or $200, excuse me, whichever is greater. Paragraph 2, any tenant in possession of premises whose possessory interest has been unlawfully interfered by the owner is entitled to recover the amount of their actual damages, $200, whichever is greater. And I think there's a position in there also for attorney fees. By changing or altering the locks, this is 2F, by causing by action or omission the termination or interruption of services provided. They called the zoning people to ask them to condemn their own house. And then they used the section of the lease option to purchase that says under destruction or condemnation of the premises, if the premises are damaged or destroyed by fire or other casual to the extent that the enjoyment of the dwelling is substantially impaired, landlord in its sole discretion may elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. Well, that wasn't even done. If the premises are condemned and cannot be repaired, this lease will terminate on 20 days written notice by either party. So on the day the zoning police show up, Mr. Bowers, Miss Bowers and Mr. O'Donnell have a lease with option to purchase effective November 15th of 2021 with 0 monthly payment. However, the testimony at the earlier hearing was they had given Miss Blair $85,000 plus an additional $15,000 plus some other money. Their testimony was they were paying $200 a month, although the lease did not require that. What's really going on is this is a purchase price for $450,000, and this house is probably worth $800,000 to $900,000. A $450,000 sale price in this market for this house is a very low price. At any rate, they called the zoning police on themselves, condemned their house, immediately kicked the defendants out, attempted to change the locks, and this action was begun. Ms. Hines was indignant, and then I said, well, I'm not sure your client has clean hands. Well, then she was more indignant. I hadn't made any finding at that point, but that was my impression at the close of that hearing. And I'd seen the zoning case. I saw the very minor damage to the deck. And then it started out as this. So the lockout law could allow the defendant to claim 3 times their actual damages plus attorney fees. So it is a summary proceeding action. There's all this other stuff circling around, but it boils down to the defendants want to execute the contract, which is a specific performance action. The plaintiff contends in some of the pleadings that she wasn't competent or capable to enter into such a contract at that time. Specific performance is an equitable remedy, mostly rests in the circuit court. So that's a concern that you should have on behalf of your client, whether they violate the lockout law, and she's going to be liable for 3 times the amount of their actual damages plus their attorney fees.
What unfolded in this courtroom was nothing short of a legal powder keg. A case that started as a simple property dispute and exploded into allegations of unlawful eviction, fraudulent condemnation, and the deliberate weaponization of the zoning system against lawful tenants. Mr. O'Donnell and Miss Bowers had a valid lease with option to purchase. They had invested over $100,000 into this property, a home with a contracted sale price of $450,000 on a house worth nearly double that. And yet, on the day zoning enforcement showed up without notice, Miss Bowers was pulled from her bed, the locks were changed, and everything they owned, snowmobiles, tools, personal belongings, vanished from the premises. The judge made his position clear. The plaintiff may have used the zoning system as a pretext to force a wrongful eviction, circumventing a legally binding lease. Under Michigan's lockout law, That could mean triple damages plus attorney fees, a legal consequence that cannot be ignored. Then came the contradiction that spoke volumes. The same contract Miss Blair used to terminate the lease is now the contract she claims she lacked the mental capacity to sign. You can't have it both ways in a court of law. At the heart of this case is a family. A father of 5 children whose life was upended. A relationship destroyed. A home he built with his own hands, now locked behind a door he's no longer allowed to open. The hearing on the 26th will determine damages, possession, and justice. But the legal and moral weight of what happened here is already undeniable. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.